All right, ladies and gentlemen, we're going to get started. So first, I just want to remind everybody if they could please turn off their cell phones before the competition gets started. Go ahead. Okay, so I'm Frank Mezzafero. I'm one of the chairs of the competition. Austin D'Souza, as you all know, is my co-chair, and he's pretty much done most of it, I think, today at least. So we want to thank everybody for being here. We have two fantastic teams. We have a fantastic final round panel. We're really excited to get this going and get this started. We want to thank everybody for coming here. We want to thank the teams and wish you guys luck. Good luck. It's going to be a tough bench, but I'm sure that you guys are up for the challenge.
Hi, everyone. I just want to say we're very honored to have, as our final round panel, the Honorable Richard A. Matazar, the Dean of New York Law School, the Honorable Wilma B. Liebman, the Chairman of the National Labor Relations Board, the Honorable Judge Peter W. Hall of the Second Circuit Court of Appeals, the Honorable Ernest Dubester of the Federal Labor Relations Authority, a member of the FLRA, the Honorable Raymond J. Loyer, Jr., a judge in the Second Circuit Court of Appeals, and finally, the Honorable Ronald Meisberg, who is partner at Proskauer and Rose and former general counsel to the National Labor Relations Board. With that said, we'd like to introduce Mr. Edmund Polachek and Mr. Kyle Kunst, the authors of the fact pattern.
Good afternoon, everybody. Whoa. Do I need this? Really? I'll give it a shot. Before we start reading the facts, I just want to echo the sentiments made earlier by Frank and Austin in thanking the entire association, Cambridge Peters, Will Dax. Frank and Austin did a fantastic job. All the members, Professor Abraham for putting up with us and all our constant demands. Sanja, who's in the back, who don't think you went unnoticed. I see you back there. Yeah. We also wanted to thank especially Professor Leibowitz on behalf of us for constantly being available to us, her constant encouragement. I called her during her lunch break and spoke to her for an hour about implied acceptance of a collective bargaining agreement, and she talked to me about it, and she discussed the facts, and she was able to flesh them out with me, and that's just one example of many that is indicative of the level of support, dedication. Come on, guys, help me out. You're in the final round. Oh, Jesus. That Professor Leibowitz has exemplified throughout the entire writing process since early September. And we, from the bottom of our hearts, both Ed and I, we really, really, really thank you. We couldn't have done it without you. So please give a round of applause to Professor. So for everybody who doesn't want to read 78 pages of the fact pattern, we are going to read the very brief summarized facts. So, Povtak v. Wagner. Since the 1950s, Cromaldi Corp. handled all the public transportation needs of Dine City in the state of Rousseau. In 2006, however, much of Cromaldi's upper management was indicted under numerous RICO predicates. Dines informed Cromaldi that the transportation contract Dines had operated under for over 50 years, would not be renewed, which was set to expire in February 2008. Prior to accepting bids for the city's public transportation contract, Dine City officials held a number of conferences with possible bidders. One such bidder was Povtak Group. At Povtak's pre-bid conference, Povtak CFO Deborah Quine, when pressed by then Cromaldi employees asking if Povtak would retain them, told the assembled audience that we'll need all the help we can get. As the lowest bidder, Povtak won the Dines contract and retained 212 of the 342 Cromaldi employees, including all 16 Cromaldi electricians. All the electricians were represented by Local 1222 of the Professional Electrical Workers Union. Local 1222 and Cromaldi had negotiated a collective bargaining agreement in which there was a traditional just cause for discharge provision and a grievance arbitration provision. As soon as Povtak assumed the Dines public transportation contract, it almost immediately began refitting the Dines fleet. In making the fleet green, more green, PovTech was awarded federal grants from both the U.S. Department of Transportation and the Environmental Protection Agency. PovTech also had to give the electricians at the Dines terminal extra training to work on the new electrical bus engines and the refitted light rail cars. PovTech also propounded an electronic communications policy, or ECP, which required all of its employees to sign an acknowledgement form, which stated that the employee had read and understood the ECP. One employee who signed the acknowledgement, an electrician working in the Dines Light Rail Division, was Roberta Wagner. Wagner believed that the ECP was a simple duplicate of the old commodity policy from 1998 and signed the acknowledgement without giving the ECP much thought. Like many other companies, PovTech created a FacePage profile. FacePage is a social networking site which allows any individual or corporation to create a profile and to become friends with other profiles. PovTech strongly encouraged its employees to become friends with its profile and to post positive comments on it, which Wagner did. Wagner had created her profile in 2006 and had set her profile's privacy settings to friends. In an attempt to build goodwill with its new employees, PovTech issued all Dines personnel with brand new e-phones. As soon as she received her e-phone, Wagner downloaded her 4 applications. 2 of the applications were work-related. One linked her e-phone to the technical support office of the manufacturer of the tram cars Wagner worked on, and the other linked her e-phone directly to her work email. The 2 other applications were not work-related. One linked her e-phone to FacePage, and the other linked her e-phone to an electrician's blog, Crossing the Wires, a public blog which can be viewed by anyone on the internet. Shortly after downloading the applications, Wagner showed them to her supervisor in the Light Rail Division, Shane Leibson.
In late February 2008, Wagner was transferred from the bus division, although she suffered no decrease in either wages or benefits. She subsequently posted on her profile, "Just been transferred to the ghetto." Several of her friends posted words of encouragement and support on her page, but one remarked that she should be careful what she posts on her profile. Wagner also posted several articles from the electrician website, Crossing the Wires, on her profile page. These were very critical of PovTech's greenness campaign and named supervisors in these articles. These postings were later picked up by the Lerner Gazette, and this is how PovTech became aware of these postings. Supervisors at PovTech were named in the article, and they were instructed to begin to search to find who this upset employee was. At around the same time as this investigation, Wagner was up for a routine job performance. And at that, they searched and they used the profile of comments that she had posted on their Facebook page. Additionally, her new supervisor in the bus division used his PovTech's sign-in and searched her page and submitted these postings to HR. They were placed into her file. She received a score of B for her performance review, which is neither positive nor negative. 2 days after her review, Wagner brought her e-phone into PovTech's technical support office because she believed the phone battery was not properly holding a charge. The technician reviewing the phone found the 4 applications she had downloaded onto them and made a note to his supervisor. The supervisor further made notes that in his reports regarding a possible connection between Crossing the Wires blog and the article in the paper. The next day, Wagner was terminated for violating the electronic communication policy. After Wagner was terminated, Local 1222 agents, Mr. Roth and Blancato, entered PovTech's Human Resources Department and submitted a grievance pursuant to Article 14.1, Step 4 of the CBA. The HR Secretary, Christian Arco, accepted the grievance, but said that HR manager was unavailable. Arco later related the information from Roth and Blancato to his supervisor. Livramento then called Blancato to schedule a meeting to discuss the ECP. At the outset of the meeting, in which all the parties were present, Livramento explained that the sole reason for the meeting was to discuss the ECP and to state that Wagner had been terminated for violating it. When Blancato and Roth told Livramento that she had to inform them that when an employee was terminated pursuant to Article 14, Step 4 of the CBA, Livramento replied that she needed no reason, that Wagner was an employee at will. And no further headway was made, and she made a comment that her door would always be open to them, but no steps were taken, and since then, litigation has pursued and resulted here in the U.S. Supreme Court.
those who have business before this, the Honorable Supreme Court of the United States, are admonished to draw near and give attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Dubester, Hall, Loyer, Meisberg, Madisar, and Chief Justice Liebman presiding. The first case on the calendar this 20th day, the month of March 2011 is Povtak Group, petitioner against Roberta Wagner and Professional Electrical Workers Union, Local 1222, respondent.
Please be seated. Proceeding will be in order, and we're ready to hear argument from the petitioner. Please begin.
Chief Justice, Your Honors, may it please the Court. My name is Sue Ann Bernard, and I, along with my co-counsel Matthew McClure, represent the petitioner, Povtak Group. At this time, I'd like to request 2 minutes for rebuttal.
Certainly.
Your Honors, we ask this Court to reinstate the District Court's ruling and reverse the decision of the 13th Circuit. Ms. Wagner has failed to establish a valid Fourth Amendment privacy claim. In addition, Povtak is not bound to Grimaldi's collective bargaining agreement. Your Honors, Ms. Wagner has failed to establish a Fourth Amendment claim for 2 reasons. First, Ms. Wagner does not have a reasonable expectation of privacy in either her company-issued e-phone or her face-page profile. And second, even if this Court finds that Ms. Wagner does have a reasonable expectation of privacy, Povtak searches were reasonable because they were justified in their inception and in their scope.
Isn't it a bit misleading for the company to have given her a phone, had her sign a policy, but nowhere in the policy is the phone covered?
Well, Your Honor, that's correct. The e-phone is not specifically stated in the policy. However, this is an electronic communications policy, and the e-phone encompasses 5 out of the 6 items listed in the policy, which is indicated in the ECP itself. It includes internet web access, hardware, software, voicemail, and is also a handheld computer, which is included in the policy. Therefore, when Ms. Wagner received this device from Povtak, it's reasonable to assume that she was aware that this was included in the policy. And just last term, this
that would include the actually making a phone call using the e-phone. Is that correct?
Yes, Your Honor, that would be correct.
So what you're telling us is that it would be okay for Povtak to listen in to conversations that Ms. Wagner has using that e-phone on duty or off duty.
Yes, Your Honor, that's correct. The policy did.
Don't you have a problem with Title III then if you're doing that, which specifically criminalizes listening to other person's phone conversations without the permission of a judge?
Well, Your Honor, that may be true, and Ms. Wagner could have a possible claim in that regard, but here it was not an issue of the phone calls that she placed on her phone. Here it was unauthorized applications that were a clear violation.
But if the policy is so broad as to cover phone conversations, isn't the policy voidable?
Well, Your Honor, that would be an issue for this Court to decide if the policy did include phone calls and messages and things of that nature. But here we're dealing with the software that was downloaded onto the e-phone.
But wasn't there some approval of that downloading of extra software by a supervisor? Didn't he then go on and encourage others to use that software, which they found to be beneficial for work purposes?
Well, Your Honor, it is indicated in the record that Shane Leibson approved of the 2 work-related applications, and he passively acknowledged that she had the 2 unauthorized applications on her e-phone. But this does not override the company policy that was put in place by Povtak.
Why is that?
Well, this Court held just last term in Quan that the lieutenant there, the police department lieutenant, informed Mr. Quan that they may look at the information that he had on his pager that was not included in the policy. But the court here held that the adoption or the passive endorsement of the company-issued device for personal purposes did not override a company policy.
I'm a little troubled by your reliance on Quan, because as I understand it, in Quan, they redacted the transcripts of the conversations or of the communications that were off-duty. And that was only an issue in Quan of the on-duty communications. Is that correct?
Yes, Your Honor, that's correct. But here the work-related applications and the non-work-related applications were on the e-phone, and that is what is at issue here, and that Ms. Wagner is claiming is intended to be kept private. But even though she may have a subjective expectation of privacy in this device, it is not a reasonable one because it is not one that society is prepared to recognize as reasonable. This court just last term in Quan assumed arguendo that the employee had a reasonable expectation of privacy. But it is imperative that this court take into account, as in Ortega, the operational realities of the workplace. And here this e-phone was a company-issued e-phone used for work-related purposes, and while it could have certain personal purposes for during non-work hours, here she was in clear violation of the policy because these applications were unauthorized.
But in what sense? Go ahead.
But counsel, isn't it true in Quan that an important part of the facts there were that all the devices in question were not covered by the policy explicitly, that subsequently the enterprise made it clear that they intended to apply them to the device, both in oral communications and then with a follow-up in writing? I don't see anything in the facts before us today that indicate that that was done here. And
Yes, Your Honor, that's correct. The pager was not specifically stated in the policy in Quan, and that was a computer policy that was put in place in Quan. And here we have an electronic communications policy that was issued to Ms. Wagner that she knowingly signed on February 9th of 2008, and she was issued a company e-phone, an electronic device, if you will. Here there's a reasonable inference.
Did she have the device before or after she signed off on the policy?
It was after she signed the policy, Your Honor. And also the policy stated that it was subject to change at any time without any notification to the employees. Therefore, it's reasonable to assume that an employee who receives a device from the company should not maintain any reasonable expectation of privacy in that device. And in addition, Ms. Wagner does not have any reasonable expectation of privacy in her FacePage profile. She knowingly became friends with PopTech on FacePage.
Because PopTech wanted her to become friends, right?
That's correct, Your Honor. They did encourage Ms. Wagner and other employees to friend them on FacePage as part of the Go Green initiative to boost company morale and to gauge the employees' feedback and positive comments on PopTech.
So they say, be our friend, and in order to be our friend, you have to sign up for Facebook. And you're arguing to us now that that gives them the right to look at and punish, ostensibly, anybody for what he or she puts on Facebook.
Well, Your Honor, Ms. Wagner was not punished for any comments that she made on FacePage. Those
Is that
comments
right? Is it not a pretext, the use of these, the misappropriation of the apps? Isn't that really a pretext for what was on her Facebook page and the disparagement of the company?
No, Your Honor. She was, she did clearly violate the electronic communications policy, and that was reasonable grounds for her termination. But here, she did become friends with PopTech because they requested her to do so, but she was not obligated to do so, and she was already friends 2 years prior, not friends, she was on FacePage 2 years prior to becoming friends with PopTech. And PopTech encouraged the employees to do this as part of the Go Green initiative and to become friends with them, but she had that.
What's the bare minimum the company had to look at in order to make a determination that she had violated the electronic communications policy?
The company could have looked at the e-phone itself and could have routinely searched it if it wished to do so, because this is company property.
Would that have disclosed the unauthorized apps, as you're calling them?
Yes, Your Honor, it would, and that was allegedly a separate search that Ms. Wagner alleged for her company-issued e-phone. She alleged
Is she dischargeable just because she had those extra 2 apps?
Yes, Your Honor, this is company property, and companies nowadays...
Why wasn't she discharged when they knew about the apps to begin with?
Your Honor, it's not clear from the record why PopTech waited, but
why did the supervisor encourage her other employees to get the same apps?
Well, Your Honor, in the record it states that he encouraged the employees to download the 2 work-related apps, and he could have passively acknowledged the use of the non-work-related apps, but Mr. Shane Leipzig did not encourage the employees to download the FacePage application or the Crossing the Wires application that was on Ms. Wagner's phone. But in regard to her face page profile, Ms. Wagner had several options in restricting the settings and who could view her own personal face page. As the record indicates at page 4, she had the settings placed to My Friends Only, which does establish a reasonable expectation of privacy from the public, but not from people that she voluntarily chooses to become friends with. And Povtak was one of those people. Therefore, Povtak did not violate Ms. Wagner's privacy.
Was it
Excuse me, Count.
Go ahead, please.
No, you say that Wagner was friends on the face page with Povtak, but how about with the Supervisor Millmine? Isn't Supervisor Millmine the individual who actually viewed the information on Wagner's personal profile? And how is Millmine's search part of the operational realities of Povtak?
Yes, Your Honor, that's correct. Mr. Millmine did use Povtak's. He was allowed to, as indicated by the record, to use Povtak's face page to conduct employee performance review searches and also to possibly look into the anonymous Puglove 86 who was leaking sensitive company information to the Lerner Gazette. But the record is silent as to whether Mr. Millmine's search for Puglove was incorporated at all into using the face page profile or Ms. Wagner's personal face page profile.
What would be the basis that would justify either Millmine or Povtak itself looking at her Facebook page, assuming she has a reasonable expectation of privacy in that page? I mean, they weren't looking for company goods, that kind of a search, and they weren't really looking for a workplace rule violation. So what would be the basis?
Yes, Your Honor. Assuming that Ms. Wagner does have a reasonable expectation of privacy in her face page profile, Povtak searches would be reasonable because to have a reasonable search, it must be justified in its inception, which is either a suspicion of work-related misconduct or a suspicion of non-investigatory work-related misconduct. Excuse me.
She was trying to get her battery charged.
Yes, Your Honor, that was a separate search, and assuming that Ms. Wagner has a reasonable expectation in the e-phone, that search would also be justified because the search in its inception would be justified because this is company property, and the technician does have a duty to make sure that the device is working properly before it is turned back over to the employee. I'd like to give you an example, if you don't mind. If my car something is going wrong with my car and I think it's the battery and I turn it into the mechanic to see if he can fix the car. Well, surely he would check under the hood, possibly see why the battery wouldn't be starting, drive the car around.
How about the glove compartment?
Where
I can rifle, if I'm the mechanic, through all of your wallet if you've kept it in there, and so on.
Yes, Your Honor, and that would be a different issue. But here, the record is not.
What if I differ with you that it's the same issue? Then in effect, the technician here was reviewing the equivalent of the glove compartment, when in fact he was tasked with just checking the battery.
Your Honor, I see your point, and if the technician had manipulated the phone or looked into the contents of the software that were on the phone, then that may not be a reasonable search because it would be outside of the scope of the search, just as the mechanics there would be no reason for him to look in the glove box. But here, the technician was looking at the phone and saw the applications themselves, which was grounds for her termination. And so this search would be justified in its inception and in its scope because it would not be excessively intrusive.
You're arguing they were in plain view?
Yes, Your Honor. It's unclear from the record that he could see comparable to an iPhone, you can see the applications on a home screen. But here, it is likely that the technician, in checking the phone and making sure it was working properly, could have seen the applications themselves before returning the phone to Ms. Wagner, making sure it worked properly.
Well, whose burden is it in connection with whether the technician saw the application? Who has the burden of showing that he saw the application?
The employee has the burden of establishing the reasonable expectation of privacy and whether the search was reasonable. And the technician would have the burden to show that he didn't go into the contents of the phone, but the record does not indicate that the technician did have to look into the contents of the phone. Instead, it indicates that he saw the applications when checking the phone to repair it and make sure the battery was working properly before turning it back over to Ms. Wagner.
Counselor, can we push you a little bit on how far this policy works? As I understand the policy, it applies both to hardware and software provided by the company. Suppose the e-phone was her own phone, but she wanted to have access to her email and so therefore created a link to the email system at the company. Would they be able then to search through the content of her own personally owned e-phone?
If she had linked her company email to the phone, Your Honor,
Yeah.
that would depend on the contents of the policy. For example, if I had
You have a policy. I'm asking about your policy where it says including hardware and software, are company property.
Well, Your Honor, her personal phone would not be company property, so she would likely have a reason to bring a Fourth Amendment claim there. But Ms. Wagner does not have.
So the critical. I want to understand this for purposes of what we're going to be writing. If your line is, if the company owns the machine that they give you, they can do whatever they want. But if you own the machine and you load everything the company has on that machine, then there's an expectation of privacy.
Your Honor, that would depend based on the operational realities of the workplace. The policy set. Your Honor, I see my time's expired. May I have a brief moment to answer your question? Thank you. It would depend on the policy that was put in place by the company, and most importantly, what the employee thought was to be kept private on the contents of that phone. Therefore, if there was a policy put in place that informed the employee that any information that was on that company phone or any company-related information that was on her personal phone could be subject to monitoring, then that would factor into whether or not that employee had a reasonable expectation of privacy, which Ms. Wagner did not have here. Thank you.
Thank you, Counsel. Good afternoon.
Good afternoon. Chief Justice, Your Honors, and may it please the Court, my name is Matthew McClure, and I represent the petitioner, PovTech Group. PovTech cannot be bound to the arbitration provision of the Grimaldi Collective Bargaining Agreement, and therefore the 13th Circuit's holding should be reversed for two reasons. First, there is no substantial continuity between PovTech and Grimaldi. And second, even if substantial continuity exists between the two companies, PovTech cannot be held to the substantive terms of the agreement under this Court's decision in Burns.
Can it be bound by the terms and conditions outside the contract? In other words, bound by the terms and conditions of employment, even if they are not a contract at this point?
Yes, Your Honor. The new employer cannot be bound to the pre-existing terms of the contract unless there are both substantial continuity between the employers and there are some additional basis for contractual liability. Now, this Court in past decisions has described the successor liability doctrine as navigating the treacherous waters. And indeed, there is some conflict between this Court's foundational holdings in Wiley and in Burns. In Wiley, this Court held that under limited circumstances, a new employer can be bound to the arbitration provision in a predecessor's collective bargaining agreement.
And counsel, aren't those circumstances virtually identical to the circumstances presented here?
No, Your Honor, because Wiley involved a corporate merger under the background of state law, which embodied the rule that the new company assumes the financial and contractual obligations of the disappearing company.
You refer to the context of the background of state law, but a central premise of Wiley, as we articulated, was our national policy favoring arbitration.
That is correct, Your Honor, and arbitration is an important and fundamental part of labor relations.
So with that in mind, who's responsible or who ultimately should be making the determination with respect to whether there is successor liability here?
The Court is charged with the responsibility of determining whether or not the new employer is the successor, and if so, what their obligations are under the pre-existing contract. However, substantial continuity is not enough to...
Why is that not an issue to be decided under the collective bargaining agreement by an arbitrator in the first instance?
Because, Your Honor, the question of successor liability is a question of law for the Court to decide, and the arbitrator's job would be to construe the contract and determine the scope, perhaps, of the liability under the collective bargaining agreement, not the question of whether or not it is a valid and enforceable agreement. That would be left for the Court.
You hired most of the employees in this bargaining unit, did you not, from the predecessor?
Yes, Your Honor.
And you didn't announce any new terms and conditions of employment in hiring them. In fact, you made it pretty clear you wanted to hire all of them, and things essentially continued as they were before from the perspective of the employees. Isn't that right?
Yes, Your Honor, insofar as PovTech did hire 62% of Grimaldi's workforce. However, there was never any affirmative offer of employment to those workers before PovTech took over operations in 2008.
So you essentially got a union-free workforce when you came in and hired them?
Not necessarily, Your Honor. Because PovTech did acquire all 16 members of the local 1222 union, they may have been under the general duty to recognize and negotiate in good faith with that union. However, to say that they have a duty to recognize the union is not the same as saying they are bound under the terms of the pre-existing collective bargaining agreement.
But are they bound by the terms that applied to the prior unit, even if it's not now a contract, but just terms from which you must negotiate?
No, Your Honor. They are simply bound to negotiate in good faith on changes in the terms of employment with that union.
But
Did you
didn't
announce?
Sorry.
Did you announce new terms and conditions when you hired the individuals?
No, Your Honor. It is not clear from the record that POVTAC did make clear to the employees that there would be changes. However, it is also not clear from the record that POVTAC has the amount of continuity that would require such notification to the employees.
Counsel, since we're making these rules up as we go along, let me ask you a question on what, as we look forward, what the best choice would be. I take it when there's a company that looks like a successor, sounds like a successor, has hired bunches of employees, including every member of the particular bargaining unit, that somebody by your reasoning has to say, oh, by the way, let's have a collective bargaining agreement that we have to now revise. Would that be correct? And they're going to have to do that step, is what you're telling us.
Do you mean, Your Honor, that the new employer must inform the old employees?
If there's a union that's on the shop, in the shop, those employees you just told us ought to be recognized as unionized employees with whom bargaining should take place at some point over something. Okay, if that's the case, shouldn't we place the burden on those who are in the best position to initiate that bargaining? And so here's a successor employer is picking up this great workforce. They have a contract that's already been in place for them. Why don't we just place the burden directly on the employer, say, oh, by the way, when you take over a bunch of unionized shop workers, tell them to sit down and what your intentions are with regard to that collective bargaining. We like this one. We don't like that one. We're not going to do arbitration. We're going to, change your sick leave policy. Initiate that process. Otherwise, aren't we frustrating the purposes of unionization and having a unionized workshop?
Perhaps, Your Honor. And going forward, the best policy may be to require employers to provide an affirmative yes or no answer to the employees and the represented unions as to whether or not the old collective bargaining agreement would apply.
So we should therefore affirm.
No, Your Honor, because under the labor policy as it stands today, there is no affirmative duty on the employers to do so. And the question when the new company takes over the old company's business is whether or not there is the requisite level of continuity between the two employers to bind them to the pre-existing contract.
Well, Counsel, you keep referring to labor policy, but didn't our labor policy in Wiley, as reaffirmed even more recently in Fall River, emphasize that the overriding policy of the Act is industrial peace? And isn't labor strife for a company like yours providing public transportation services particularly chilling, not just in terms of its impact on the employees affected here, but possibly in terms of thousands of citizens and maybe even in terms of possibly shutting down a city?
Yes, Your Honor, and it is important to protect the employees of POVTAC from sudden changes in the workforce, but it's also important to protect employers, especially public service providers such as POVTAC, from assuming disadvantageous collective bargaining agreements that they have neither adopted nor otherwise abided to.
But in this case, didn't POVTAC comply with step 4 of the existing grievance procedure in the old contract? And if that's the case, why shouldn't we at least hold POVTAC responsible for adhering to that provision?
No, Your Honor. POVTAC did not adopt the Article 14.1 grievance procedure outlined in the collective bargaining agreement. Ms. Livramento did set up a meeting on March 10, 2008 with 2 union representatives, Roth and Blancato, but she informed them prior to this meeting that the sole purpose was to discuss the terms of the electronic communications policy under which Ms. Wagner was terminated and not to resolve her grievance over her termination.
But why was she having any discussions with them at all?
Well, Your Honor, Ms. Livramento's justifications and reasons for holding that meeting are not entirely clear from the record, but it may have been her belief that POVTAC was under a duty to recognize and negotiate in good faith with that union, and therefore felt the need to insulate POVTAC from potential liability for failing to do so by meeting with the union and discussing in amicable terms.
Counsel, that takes me back to where I was a couple minutes ago, which is if they all thought there was a union, they all believed, the employees believed they were part of a union, the employer was treating them as if they're part of a union, there was a collective bargaining agreement that they had bargained with their prior employer, they are all working for in the same kinds of jobs they had when they got there beforehand, why wasn't it reasonable to believe that that arbitration clause was both enforceable and still enforced if the company itself hadn't, any time before then, sat down with the union and said, by the way, we don't like these clauses? Because,
Your Honor, POVTAC, in taking over, created a substantially different business that used different operations and a different business mission than Cromaldi had, and therefore the employees...
How could you possibly say that?
And isn't the inquiry really from the perspective of the employees, and from their perspective, how could you say anything is different?
Yes, Your Honor. Under Golden State Bottling and Fall River, the the crux of the substantial continuity analysis is the employee's perspective and whether they reasonably view their jobs as unaltered after the change in ownership. And here, after PovTech took over operations, they changed the business mission from a traditional transportation company.
Forget about the mission. What is it? What did the employees reasonably see with respect to their own jobs? As I understand it on the record, the only difference was the electricians who may have had to do a few additional things related to the environmental aspect of PovTech, but there were no other differences from the employees' perspective.
Well, Your Honor, under the second prong of Fall River, we are to look at the jobs, working conditions, and supervisors at the new business. And here, they were different under PovTech than under Cromaldi.
So you were conceding that from the employees' perspective, there was no significant difference. Is that correct?
No, Your Honor. We would suggest that the differences between the two companies were significant. The electricians at PovTech were now charged with not only performing their standard electrician duties, but with servicing electric engines on the PovTech buses. And the district court noted that their job duties had increased.
So when the New York Jets are sold in a couple of weeks and they bring in a new coach and a new group of managers and they move from having a spread formation to having an I formation, it's a very different business then, all those union agreements would go away, you think?
No, Your Honor, if the rest of the business was substantially similar as it had been
like
before.
still playing football.
Correct, Your Honor.
So that's still like having transportation that takes you from one place in the city to another place in the city?
No, Your Honor, because the manner of the delivery of these services had changed so substantially.
Remember, we went from the I formation to the T formation. Those are very different ways of delivering the ball to the receiver.
Perhaps I could direct the court to a decision from the D.C. Circuit from 1995, City Steel USA versus NLRB. In that case, a Chinese corporation purchased an American steel mill and converted it from a traditional steel mill to what was known as a mini mill, which was a smaller scale, higher efficiency business that produced a limited number of steel products, but did so at a higher level. And in that case, the D.C. Circuit Court found that even though they were engaged in the general field of steel mill production and that had not changed, the two businesses' operations had changed so substantially that there was no continuity any longer between the two businesses.
Well, assuming there was continuity, would you concede that at a minimum you would be bound by the terms and conditions of employment that previously applied to these workers in the jobs that are at issue, even if you're not bound by the labor contract? Will you concede that much as a perfectly clear successor?
We would concede that PovTech may be bound to recognize the union, yes, Your Honor, and negotiate the terms of employment going forward.
So you would be bound by the existing terms and conditions. Would that include the duty to arbitrate, or is there some reason why that's not included in the existing terms and conditions?
Well, Your Honor, no, it would not include the duty to arbitrate.
Why not?
Because there has been no valid and enforceable agreement to arbitrate in this case that is enforceable against PovTech. And as this court held in 2000...
Because the agreement doesn't exist?
No, Your Honor, because PovTech was not a party to that agreement and has not shown its adoption of that agreement. In 2009, this court held in Granite Rock Corporation that there is an important policy in favor of arbitration, but that it does not attach unless there has been a valid and enforceable agreement to arbitrate. And in a case such as this, where the very essence of the debate is the existence of an enforceable contract, that policy in favor of arbitration...
Why isn't that issue in and of itself one that is arbitrable essentially in relation to the contract, not as a result of?
The application of the...
Why shouldn't you be arbitrating whether there is the scope of the existing agreement?
Your Honor, because under Burns, the successor cannot be bound to that agreement. And so even if this decision was to proceed to arbitration, the arbitrator would have no valid contract to construe or terms to enforce. This was noted by the Third Circuit in the Ameristeel Corp versus Teamsters decision.
But what about that brilliant decision out of the Second Circuit?
You're saying that judge, the brilliant judge in that Second Circuit decision, got it wrong.
No. I had a feeling that decision would be discussed today, Your Honor. In the Meridian Management case, that involved a different factual scenario in which a corporation enlisted another corporation under a subcontract to perform janitorial services at an airport terminal. And in that case, the court found that the employees of the subcontractor essentially knew they were working for the larger corporation the entire time, which makes that case more akin to Wiley, where there has been no change in corporate identity. In this case, we have the assumption of a contract and the change in the way the business was operated. And although Meridian Management does stand for the fact that in certain cases arbitration can survive, we would urge this court to find that Meridian Management is simply more in line with Wiley, and that in cases of high continuity in the old and new businesses, the duty to arbitrate can survive.
Can I ask a policy question?
Yes, Your
These
Honor.
employees had this contract negotiated for them. Why shouldn't they be able to, I guess I'll hold my question since I see that time is up.
Thank you, Your Honors.
Should I go ahead? Yeah, no. Okay. Let me ask the policy question. Why?
You're the Chief Justice after all.
Why shouldn't these employees have at a minimum the procedural protections of this agreement, even if not the substantive protections of this agreement, which was negotiated on their behalf? Why should they lose that just because there's been some kind of a business transaction?
Because, Your Honor, arbitration provisions, even though procedural, are still a substantive part of the collective bargaining agreement. And since under Burns, the unconsenting non-alter ego successor cannot be bound to that agreement, this POVTAC should not be required to arbitrate or held to any other substantive terms of that agreement. And even though the employees may have relied on the arbitration provision, that reliance was not reasonable in this case because of the substantial changes that occurred in the company that gave them notice that they were no longer working for Cromaldi. They were now working for a different company with different operations and different business mission. And therefore, this court should reverse the holding of the 13th Circuit. Thank you.
Thank you, Counselor. Now hear from respondents. Good afternoon.
Good afternoon. Thank you, Chief Justice, and may it please the court. My name is Lawrence Hilton, and along with co-counsel Christopher Alessi, together we represent the respondent, Ms. Roberta Wagner, and Local 1222. Today I will demonstrate that Ms. Wagner's Fourth Amendment rights were violated in the search of her face page profile and her e-phone. Mr. Alessi will address the issues pertaining to the collective bargaining agreement. Now, Ms. Wagner's Fourth Amendment rights were violated for two reasons. First, she had an expectation of privacy in both her face page profile and in her e-phone. And secondly, pursuant to this court's decision in O'Connor versus Ortega, the search was unreasonable. Thus, we respectfully request that this court affirm the judgment of the 13th Circuit. Now, with respect to the subjective and objective expectations of privacy, this court in Katz versus the United States noted that an individual, in order to successfully allege a Fourth Amendment violation, must show both a subjective and objective expectation of privacy.
That's involved a phone booth, is that right?
It did involve a phone booth, Your Honor.
And so is Facebook or FacePage the new phone booth or the new water cooler, which would be, I guess, presumably more open to the public?
It is the new phone book, Your Honor. In 1967,
Phone book or phone booth?
Phone booth, I apologize, excuse me.
Didn't want to get a third term in there.
In 1967, this court noted that phone booths played an important role in private communication, and thus this court held that the individual in Katz had an objective expectation of privacy.
But what if in Katz there had been a big sign posted, and we're going to assume that Mr. Katz can read, and it said, anything that you say in this phone booth may be subject to discovery and viewing and reviewing or overhearing? Would he have had a subjective, reasonable expectation of privacy?
At that point, he would not have had a subjective expectation.
So what is the difference between that and what Ms. Warner got by way of the electronic communications policy that she signed off on?
Well, respectfully, Your Honor, the electronic communications policy that the petitioner relies so heavily on simply isn't on par or on point in today's case.
Because?
Well, the electronic communications policy in the first paragraph, the first sentence, outlines the electronic systems that are covered within the policy. And the e-phone is not covered within the policy. And as the petitioner...
It says, Mr. Hilton, hardware.
It does say hardware, Your Honor.
Doesn't that encompass an e-phone that's provided by the company?
No, Your Honor.
Why not?
Well, as the petitioner noted, the e-phone was given to Ms. Wagner after she signed the electronic communications policy. Now, if the petitioner wanted to include the e-phone as part of its policy, then as the employer, it had the responsibility to include the e-phone as one of the electronic systems. However, it did not.
Well, it did. It said electronic systems include hardware.
Yes, Your Honor, and that is
So it's very broad language, wouldn't you agree?
I would agree that it is broad language. However, I would also agree that that is an exclusive list. It lists computers, internet and web access, emails, voicemails, and it does not preface it by saying such as.
But
This
what is hardware?
Hardware might be considered an e-phone, it might be considered a computer, however, it's not clear. And as the Northern District of Illinois noted in Mays versus Florberg, when there is a policy that is in place that is either unclear or ambiguous, an employee can have both a subjective and objective expectation of privacy in the instrument that's been issued to him or her.
So, Mr. Tilton, let me see if I understand what your argument is. You got a policy that says all electronic systems, including hardware and software, are company property. It says the company reserves the right to recover its property at any time with or without demand. So if they wanted the phone back, do you think they wouldn't have the authority to do that?
Well, they would be able to possibly get the phone back simply because it was.
Possibly. I mean, in your reading of this clause within the policy, could they have asked for the phone back?
They could have asked for the phone back, but not because of my reading of that clause.
And she understood that the phone that she had in her hands was not hers. She didn't own it.
Respectfully, Your Honor, I would have to disagree.
Ms. Wagner thought that they gave her this phone purchased by the company with the company's little, sticker on the back that says property of us, and that's her phone now. She owns that. She could sell it?
She did not believe that she owned the phone. However, on page 4 of the record, it indicates that the phone was given to the employees as a token of goodwill. It's not similar to Quan.
It's a token of goodwill, but I just want to understand what the phone does. It does electronic mail system because it says all messages sent and received on the electronic mail system or remain the property of the company at all times.
It does perform the electronic
It does email,
mail.
right?
Yes, Your Honor.
And that says these are not the private property of any employee, and users should not maintain any expectation of privacy. So you said the standard is a reasonable expectation of privacy. She signed the thing. It's a piece of hardware. It does email. It's owned by the company. So explain to me why that's reasonable, that she should not believe that they could get the stuff back off the phone?
Well, based on the policy that Your Honor quotes, in that policy, it does not specifically mention an e-phone. And this court noted in Katz that a reasonable expectation is one that society is willing to prepare to recognize as reasonable.
So,
and society.
So when the company makes its policies, it needs to anticipate all changes in technology. Would that be what companies in the future have to do? Cloud computing, would that count?
In order to keep its employees abreast on what the employees are to maintain an expectation of privacy in, absolutely, Your Honor. Now, in Katz versus the United States, we were talking about a phone booth a few moments ago, and this court noted that when an individual walked into that phone booth, shut the door behind him, he had a subjective expectation of privacy that the information he relayed on that telephone call would remain private. In this case, when Ms. Wagner set her privacy settings on Face Page, she affirmatively took the step and closed the phone booth so that individuals would not look at the information that she posted on her own private page.
What if somebody who was a friend of hers on Facebook took that information and put it out there? What does that do to her expectation of privacy?
Well, as Justice Marshall noted in Smith versus Maryland, privacy is not a discrete commodity possessed absolutely or not at all. Simply because one shares information with one person for one purpose doesn't mean he expects it to be shared with another person for another purpose.
But is it subjectively reasonable for a person with a Facebook page to expect that anything that she puts on that page is not going to get out into the public, either via a friend, Potvak was a friend, or any other friend that she had on Facebook, or because of some policy?
In this case, Your Honor, it is, because in this case, Ms. Wagner befriended Potvak as a company and not an individual. Thus, she subjectively believed that she was only becoming friends with the company because it instructed her, or strongly encouraged her to become friends with it for the sole purpose of posting positive things on its Face Page profile, which she did. And she posted positive things on Potvak's Face Page profile. However, on her own personal Face Page profile, she didn't post as positive things. Thus, this shows her subjective belief that the information that was posted on Potvak's Face Page profile would be the only information that Potvak would view.
Is it your position that she was discharged because of what she put on her personal Facebook page?
Absolutely.
That disparage the company, and what is your claim to that? What's your evidence for that, as opposed to the fact that she was discharged for these unauthorized apps?
Well, Your Honor, based on the fact that the electronic communications policy does not apply, and it's a stretch to apply the electronic communications policy to
Let's
Ms.
say it applies. Let's say, for the sake of argument, that it does apply. The policy applies.
Well,
to
even
the
if the
to the e-phone apps.
I apologize, Your Honor. Even if the policy does apply, PovTech was upset that one of its employees was posting things that weren't as flattering to the company on her own private face-page profile. And the electronic communications policy, if this court assumes that it does apply, was simply a pretext in order to release Ms. Wagner from employment at the PovTech group.
Well, pretext or not, does it matter? She, if it applies, did not have a reasonable expectation of privacy. Is that?
If this court determines that it applies, Your
That should be
Honor,
the end of the story, at least with respect to the Fourth Amendment claim. Is that correct?
Yes, Your Honor, because according to this court's decision in Katz and its progeny, the basis for a search in the Fourth Amendment means that an individual must have an expectation of privacy.
So if this policy applies to the e-phone, that is, she cannot prevail on her Fourth Amendment claim. Is that correct?
Yes, Your Honor, but respectfully, the electronic communications policy in this case does not apply.
You keep saying, counsel, that it does not apply, but just last year in Ontario versus Kwan, in that case there was a policy, and the device in question was not literally covered by the policy either, just like here. And yet we found, based on the circumstances there, that a search of a text message sent from a government-issued cell phone was reasonable, and we did not find a violation of Fourth Amendment rights. Why should we change our decision from last year?
Yes, Your Honor, because the situation here is completely distinguishable from the situation that was brought before this court in Kwan. In that case, it was an official pager that the employees were to use for work-related purposes. And as I stated before, on page 4 of the record, it indicates that this was simply given to the employees as a token of goodwill. Nowhere in the record does it state that the the e-phone was given to the employees for a work-related purpose. Thus, it's completely distinguishable from Kwan in that manner, which brings me to the reasonableness of the search. Now, in Kwan and in O'Connor, this court noted that a search is only reasonable if it is justified at both its inception and in its scope. Now, an opposing counsel compared this case to that of a mechanic who was going to turn on the car. Now, if this court is comfortable with that analogy, then in this case, PovTech's technical support team turned on the car, took it for a ride around the block, and looked at everything that was in the secret enclaves of the car. PovTech turned on Ms. Wagner's phone, and they didn't simply see if the battery was working or not. It actually went into the phone to see the applications that she downloaded on the phone.
But in this case, I think that the difference, and one of my colleagues alluded to this, the difference is that they own the car. Isn't that correct?
PovTech.
The e-phone is the company's property. If we believe that, and if we make that determination, then the car analogy that you're proposing doesn't work. Am I wrong about that?
Respectfully, Your Honor, you are. In United States versus Finley, the Fifth Circuit was noted that even though the company owned a computer, which was at issue in that case, because it was under the exclusive control and dominion of the employee had an expectation of privacy in it. Now,
Why
in
was
this,
she turning in the phone to the company to fix the battery if she thought it was her phone?
well, Your Honor, I'm sorry, are you referring to the reasonableness of the search at this point?
Ms. Wagner, if she believed it was her phone, why is she asking the company to fix her phone?
Well, this goes to establish, if she believed it was,
Hey, company, you gave me a crappy phone. Fix the battery on the crappy phone you gave me. If it was hers, wouldn't she just take it down to the local store and have someone give her a new battery?
she could have taken it to the local store, or she could have turned it over to PovTech's technical support team to look at it.
And that was just a kind service that they do for their employees, taking public funds and using them to service private phones that are owned by people who are taking their private stuff in. She brought a private computer from home in, too? have that one be fixed by the folks over at PovTech?
It's quite possible, Your Honor, since the record states that PovTech was giving employees phones to build goodwill amongst its employees.
But the company also obtained an advantage from her having the phone, did it not? Because they liked how quickly she could respond with several of the apps that they did approve of.
The company did obtain this advantage. There's no doubt that because this phone, Ms. Wagner was a more productive worker at the workforce. However, this does not diminish her expectation of privacy, and it doesn't make the search any more reasonable.
I'm not arguing with you. I think that's sort of analogous to having a company computer and still having an expectation of privacy in it.
Absolutely, Your Honor. Now, with regards to the inception and the scope of the search of the face page profile, again, this court noted that in order for a search to be justified at its inception, it must be for a non-investigatory or an investigatory purpose. Now, the record indicates that company headquarters informed its supervisors that the supervisors were to look at PovTech's face page profile and to determine if the employees were making positive comments on PovTech's face page. Now, in conducting this search, Mr. Milmeen, Ms. Wagner's supervisor, well, he took it a step further. He didn't only look at PovTech's face
But
page.
the inception of the search, it seems to me, Mr. Sultan, related to a faulty battery. Isn't that how we're supposed to look at this?
The inception of the search, I'm sorry,
Of
Your
the
Honor.
e-phone.
Of the e-phone. Well, Your Honor, with regard to the inception.
That was a technician, was it not?
It was a technician. However, Your Honor, it wasn't justified in its inception because, as this court noted, it must be for a work-related purpose. And when Ms. Wagner turned over her e-phone, she wasn't turning it over so it could be fixed for a work-related purpose. She was turning over her e-phone simply so that it could be fixed. And because it wasn't for a work-related purpose, Your Honor, it's justified in its inception.
She had a limited right to use this for personal matters as well. Is that correct?
Respectfully, no, Your Honor. It's not correct.
Could she have been downloading Tetris? You're suggesting it's not for work purposes that she had this phone, so if she put Tetris on or Angry Birds. She could have an Angry Birds app.
Chief Justice, may I respond to that question?
Yes, you may.
Yes, Your Honor. She could have downloaded Tetris or Angry Birds or any other game onto the phone. However, when the petitioner began to search the phone, the search was no longer justified in its inception or its scope, and we respectfully request that this court affirm the judgment of the 13th Circuit.
Thank you,
Your
counsel.
Honors.
Thank you.
Maybe my colleague can tell me what Angry Birds are.
You don't want to know.
Nasty bird. Oh.
Good afternoon.
Good afternoon. Madam Chief Justice, and may it please the court. My name is Christopher Allisey, and I also represent the respondent, Local 1222 Professional Electrical Workers Union. Your Honors, the 13th Circuit correctly reversed the district court's judgment because there is sufficient continuity and identity to bind PovTech by the terms of the pre-existing collective bargaining agreement. And even if substantial continuity and identity alone is insufficient, PovTech should still be bound either as a perfect successor or because it impliedly consented to the terms of the agreement.
Did the union ever make a demand of PovTech to comply with the terms and conditions of the prior agreement?
Certainly it did, Your Honor. When the union filed the grievance related to Ms. Wagner's termination.
That's sufficient for a demand, just filing a grievance?
Well, Your Honor, the union was present around the company, as noted by Christian Arco's deposition on page 7 and 8, where he states he did recognize the Local 1222 business agents as being present around the company.
Well, that's different, though, than recognizing 1222 as the exclusive collective bargaining agent for the people at the company, right?
Well, certainly, Your Honor. However, once PovTech decided both to retain a majority of Cromoli's workforce and also to substantially continue business operations, it did make the decision that it was forfeiting its right to set initial terms and conditions of employment and had accepted the terms of the collective bargaining agreement. And as a result, the union did not need to make a demand. However, it did continue to make its presence known in the workplace, and it also presented a grievance pursuant to the collective bargaining.
Is accepting the terms the same as accepting the contract?
Absolutely, Your Honor. In this scenario, yes, Your Honor. In this scenario, it is. In that a new employer should not be able to maintain terms and conditions of employment simply to pacify the workforce and prevent labor unrest, and then at a later time, when those terms are no longer convenient, simply disregard them, as PovTech attempted to do in this case
when Ms. Livermento and George Dax stated that PovTech was still at will. Now, Your Honors, this relates to the implied consent exception if substantial continuity and identity is actually insufficient. And by maintaining terms and conditions fundamentally similar to the collective bargaining agreement, PovTech had impliedly consented to those terms and should be bound by the entire agreement.
See, I thought our jurisprudence was that if you were a perfectly clear successor, you had an obligation not only to recognize the union, but to respect the terms and conditions that were in effect at the time the acquisition was made. But I don't read our jurisprudence to mean that you are bound by the contract. What you must do before you can change those terms and conditions is bargain with the union about it in collective bargaining. So where do you make the leap that these terms and conditions actually constituted a contract?
Well, Your Honor, it is actually a contract in that PovTech did impliedly consent to the terms. As it relates to the perfect successor test, Your Honor is correct that PovTech would only be bound to abide by the terms until the parties could negotiate a new terms and a new collective bargaining agreement. However, until that time, PovTech would be bound by the existing.
Where is the evidence of implied consent here?
Well, Your Honor,
on the record.
Your Honor, implied consent is shown in, first, the fact that PovTech did substantially maintain the same terms and conditions, including checkoffs. In Article 13.2, the collective bargaining agreement notes that checkoffs would be deducted from employees' pay and paid to the union within 1 week of the end of the month. PovTech assumed control of the company near the end of January and in early February, and Ms. Wagner was not released until sometime in late February. During that time, there would have been one instance in which there were checkoff dues deducted and paid to the union. And if there hadn't been, the union certainly would have raised an issue. And that is unclear in the record whether or not PovTech did so, but the fact that the union did not dispute this, a reasonable inference is that PovTech did keep checkoff dues and also maintained sick leave, vacation time, wages, and all other terms and conditions of employment as a means of pacifying the workforce and preventing labor unrest. And a new employer cannot rely on terms and conditions of a collective bargaining agreement and act under those terms and conditions only to disregard them later, as it would be contrary to the expectations of the employees in continued union representation and a binding collective bargaining agreement that represents the common law of the workplace.
Let's say we
Please go ahead.
Let's say we disagree with you that the contract was essentially impliedly adopted or a perfectly clear successor. So we get to the normal successorship situation. Isn't the transaction here really more akin to what happened in Burns than when it happened in Wiley, or that Judge Becker talks about in his dissent in the Third Circuit case?
Well, respectfully, Your Honor, this case is most like Wiley, and as a result, Wiley should be the controlling precedent before this court.
How is that?
Well, first, Your Honor, and most importantly, there was a wholesale transfer of the bargaining unit. All 16 members of Local 1222 were employed by PovTech as electricians as they were from Cromaldi. And in addition, the Local 1222 did file a Section 301 claim to enforce the collective bargaining agreement. And further, Your Honors, even though there wasn't exactly a merger in this case, as the Second Circuit noted in a very well-written opinion in Meridian, Local 348 versus Meridian Management, even absent an express merger, when the predecessor is no longer able to have an agreement enforced against it, the union's expectation is that it should be enforced against the successor.
The factual scenario was much different in this case than it was in the Second Circuit case, where the company just took the work back in-house.
And also, counsel, isn't the fact situation significantly different from Wiley in the sense that clearly, almost immediately upon assuming responsibilities for providing service, the PovTech began making significant changes. It made changes in the buses themselves in terms of the engines that it was going to be using. It made significant changes in the bus routes that it was going to be using to provide the transportation services to citizens, and it made changes in the job responsibilities of the electrical workers. That's much different from Wiley.
Well, respectfully, Justice Dubester, I would address the Chief Justice's question first. And in this case is similar to the Second Circuit in that there is still the City of Dines as the overall company, in effect, for which these employees are working as public employees. While there has been a change in the contract,
The fact is, these employees are still working for the citizens of Dines as public employees, similar to Meridian, where those employees were merely switched from a subcontractor directly to the general contractor. And now to address Justice Dubester's concerns regarding the changes that PovTech attempted to make to the workforce were insufficient to make a reasonable employee believe that the workplace has in fact been altered. First, Your Honors, while PovTech did refit the buses with electrical engines, first, it doesn't change the fact that they were the same buses used by Grimaldi. And while there are new engines, renovations alone do not defeat substantial continuity and identity. In NLRB versus Interstate 65, the Sixth Circuit noted that a motel that renovates its rooms is still a motel. Those rooms are still used by customers that are spending the night. And similarly here, new engines don't change the fact that these are still buses, and the buses are still transporting citizens of Dines. And because of these engines, the Local 1222 electricians did have to undergo a little bit of additional training and have one additional job duty. However, the collective bargaining agreement itself anticipates that the Local 1222 electricians will undergo additional training. In Article 3.2 of the collective bargaining agreement, it notes that the electricians will be required to undergo additional training as necessary, specialty training, in order to meet job duties as they arise. And in the 51 years that Local 1222 represented the PovTech or the Grimaldi electricians, it's reasonable to assume that they would have had to undergo additional training, as technology certainly changes over 51 years.
Let me go back to the question of the. Go ahead.
No, go ahead.
Let me go back to the question of the existence of a contract. You filed your suit before the district court under Section 301 of the LMRA. Is that right?
Yes, Your Honor.
And that is gives federal courts jurisdiction to hear suits on contracts between labor organizations and employers. Is that correct?
Yes, Your Honor.
Did you plead the existence of a contract?
Yes, Your Honor.
Did the company deny that?
Yes, Your Honor.
So that is an issue in this case.
Well, Your Honor, there is an existing contract in that substantial continuity and identity alone does bind a successor employer by the terms of a pre-existing contract. And in binding the successor to the terms of the contract, there is effectively a contract between the labor representative and the new employer.
So just so I'm clear, does the 13th Circuit hold in its opinion that, the respondent here is the successor employee and therefore bound?
Yes, Your Honor. The 13th Circuit did hold correctly that, pursuant to this Court's opinion in Wiley as the controlling precedent, PovTech is indeed bound by the terms of the contract, specifically the Article 7 Just Cause provision.
Isn't there a middle ground here, though, that it can go back to arbitration, or we can send it back to the circuit, to the district court, to send back for arbitration the scope of the contract?
Absolutely, Your Honor. And if this Court so determines, Local 1222 would be perfectly happy to arbitrate the extent to which PovTech may be bound. However, this Court should first determine that PovTech may in fact be bound. Otherwise, as petitioner does assert, arbitration would in fact be futile.
So you don't disagree with the petitioner here, with PovTech on that point?
Well, certainly, Your Honor, arbitration would be futile if PovTech could not be bound by the terms of the agreement. And this Court should decide that PovTech may be bound based solely on substantial continuity and identity. And to return to Justice Dubester's concerns about the changes, PovTech did alter the route slightly so that it is more efficient and it could serve a few more of Dines citizens. However, under Fall River, this Court noted that the essential issue is whether the class of customers has changed. And in this case, the Local 1222 employees are still servicing buses that are still serving Dines citizens, just as they did with Grimaldi. And they're doing so out of the same facilities, in the same manner that they always had, and the only additional duty is one that was anticipated by the collective bargaining agreement. And in addition, PovTech...
They're actually arguing a little bit more than that, I think. And it's that the nature of the business, that is the environmental aspect, fundamentally changes the business from what it was under the Grimaldi Corporation.
In this case, it does not, Your Honor, in that under the collective bargaining agreement, Article 15, management does retain the right to direct the mission of the company. And Local 1222 does not dispute that fact. However, in the eyes of a reasonable employee, they still wake up and go to work and do the same thing every day.
Mr. Alsey, do you see a conflict between your argument and your colleague's argument, Mr. Tilton? He tells us that, a phone is not the same thing as a bunch of other technology, so this new technology came in, so it's clearly a different thing. Now, these guys are using different engines, different bus routes, all sorts of different business tactics. They're going to be serving slightly different customers, and they're going to have green instead of brown technologies. Sounds to me like the two of you guys don't have your act together in terms of what you think changes of conditions of the business mean in terms of whether or not we should how we should treat these issues. What do you think?
Well, respectfully, Your Honor, I disagree. I think the arguments are, in fact, consistent in that, in this case, a reasonable employee would not believe that his workplace has, in fact, been altered, whereas Ms. Wagner would reasonably believe that the ECP only covers the objects that are explicitly described in the ECP. She would have no reason to think otherwise, and in that it was vague, Ms. Wagner reasonably believed that the ECP, or that the e-phone was not covered. However, here, the Local 1222 employees would certainly have no reason to believe that there have been any changes in the workplace, in that PovTech has, in fact, retained these workers specifically for their expertise in their field. Now, in page 14 of the 13th Circuit's opinion, it notes that these employees had to undergo rigorous training, apprenticeship training, in order to advance to the level of journeyman. And in doing so, they have established expertise in electrical fields. And PovTech is utilizing that expertise and adding one small additional duty that is anticipated by the collective bargaining agreement and expects that to defeat substantial continuity and make the employees believe they are now doing something new. These employees are servicing buses. Those buses are serving the citizens of Dines, and those buses are still working out of the same facilities in the same manner. And that is exactly what Cromaldi did, and now PovTech is doing the same.
Why is this not like what your adversary argued, not more like what your adversary argued in terms of the steel mills and the big steel mills, traditional pours and manufacture, and the smaller, more specialized steel mills?
Well, Your Honor, in City Steel, the D.C. Circuit also noted that there was a $25 million renovation to the facility that completely changed the shape of the facility itself. And in addition, the employees actually complained about their new job duties, believed that the new job duties were more difficult than their previous duties, and in doing so established that those employees couldn't reasonably believe their workplace had not changed. Here, the Local 1222 electricians were already very well trained, and one simple additional duty should not defeat substantial continuity and identity. Now, Your Honors, I see I'm short on time, and I would briefly like to return to the perfect successor argument. Now, an employer is a perfect successor bound to negotiate with the union regarding terms and conditions of employment to impasse before unilaterally making changes if it misleads the employees into believing they will be rehired and fails to state that it would be changing the terms and conditions.
Counsel, are you suggesting that the one statement made by PovTech's CFO that PovTech would need all the help it could get, that one vague statement about potential future labor needs is sufficient to bind PovTech here?
Absolutely, Your Honor. In the context in which that statement was made, the statement was made at a pre-bid conference called by city officials and attended, Your Honor, I see I'm out of time, if I may briefly.
You may finish your answer. Thank you.
The meeting was attended by Cromaldi employees as well as city officials concerned about what would happen to those employees if PovTech took over the operations. And Ms. Quine's statement that PovTech would need all the help it can get would certainly lead employees to believe in those circumstances they would be rehired, and PovTech then failed to state that it would be changing terms and conditions of employment. Thank you, Your Honors.
Thank you, Counsel. Rebuttal?
Briefly, Your Honor.
Yes.
May it please the Court. The respondents have asserted that PovTech maintained the check-off, vacation, and severance pay provisions in the collective bargaining agreement. And while this is perhaps a resourceful plea, it is not one that is supported by the record. To the contrary, on pages 5 to 7 of the record, it is clear that Ms. Roberta Wagner made posts on her personal Facebook profile criticizing the new green initiatives at PovTech, as well as her new working conditions and the jobs performed by her new supervisors. Therefore, it is clear that the electricians at PovTech were aware that they were no longer working for Cromaldi, and they were now working for a new business, PovTech.
And in fact, you didn't continue dues deductions?
It is not clear from the record, Your Honor, and whether or not the union had objected to that is not something that is supported by the record. And because there is no evidence that the union objected, and because there is no substantial continuity between these businesses, we ask this Court to err on the side of protecting the employer's right to structure its business and reverse the holding of the 13th Circuit.
Would the answer to that question be determinative of the outcome?
No, Your Honor, because this would be determined in the total comprehensive view, the totality of the circumstances under whether the two businesses were substantially continuous. However,
So do you have an argument without it?
yes, Your Honor, because even if the two businesses are substantially continuous in this case, there are no additional justifications under the alter ego, voluntary adoption, or perfectly clear successor exceptions argued by the respondents, because the business here made no clear offers of employment and did not show any attempt to adopt or abide by the procedures outlined in the collective bargaining agreement.
Mr. McClure, let me just understand one thing that you said earlier, now that I've got you back. I thought that I understood that you conceded that prospectively the burden should be put on the employer to affirmatively decline being found bound by the CBA. Is that correct?
In certain circumstances, yes, Your Honor.
Why shouldn't we draw that line now? Why shouldn't we have that rule now in this case?
May I respond to your question, Your Honor?
Sure.
In this case, it's not necessary because the two businesses are so different that the employees had no reasonable assumption that the union would carry over and that its collective bargaining agreement would survive the change in ownership. But in cases where there is a question of continuity in the old and new businesses, and they are similar, it would be advisable for the union or for the new employer to advise the union in advance that the old collective bargaining agreement no longer applies. Thank you.
Thank you, Counselor. Thank you.
All rise.
Sorry about that, Chief Justice.
Please be seated. Someone else is going to do that. Well, we all very much enjoyed this argument. It was a tough argument, some really interesting issues, and you all did extremely well. We were extremely impressed by everyone and how well all of you just navigated back and forth with all the questions. So our choices were difficult choices, which is why we took so long. We had a lot of discussions, and it was very close. But ultimately, we had to make a decision, and our choice, our vote for best oral argument goes to Mr. Alessi. We very much enjoyed your argument. It was extremely clear. You gave some great answers. We talked about one where you brought it back to the fact that ultimately the city was the employer here of all these people in essence. You gave very good answers and moved back and forth between the questions very deftly. So congratulations. We were very impressed. And again, then we had to make a choice about the best team. And again, it was a close decision, but we went with Mr. Alessi and Mr. Hilton as the best team. And our congratulations to you as well. You did a wonderful job. We were very impressed. Some of you had some pretty hard arguments. So I turn to my colleagues to see if they want to make comments individually.
Since I'm junior, I'll let...
You want me to start?
Yeah.
Well, I just want to quickly reaffirm what the Chief Justice said about just how impressed we were with all four of the finalists. And quite frankly, at this juncture, because I know you've done it several times, I expected your answers to be good. I expected you to be well prepared, but I was, by degree, very impressed with the depth and breadth of your recitations. I mean, I expected you to be able to cite a lot of the major precedents, but you really were pulling cases out of the air with citations, and I really, and often with rapid-fire responses, and I just thought that was very impressive. And the other thing I just want to say quickly, and until you really participate in this, my whole professional life has involved labor management relations and the employment arena. I thought the issues were great. We've already given credit to the drafters of the fact statement. But the other thing is just in terms of skills, when you see this, I'm in a quasi-judicial position right now where I have people that are basically law clerks that are writing for me, but we're starting to stress the full balance of people that have communication skills across the board, not just good writing skills, but great oral advocacy skills. And I think that the great thing about this competition, I know we didn't see the writing skills today, but I know that the briefs have been an important part of your moving through the various rounds. But to have that complement of both the writing as well as the oral advocacy, I just think is so great. And I just wanted to say that and certainly appreciated what you did.
Speaking for myself, I've had several labor issues that I've had the privilege of sitting on panels to decide. And I've now I'm a little less wet behind the ears than I was a while ago, and 7 years on the court. I would be honored and pleased to have any one of you, and I mean this from the bottom of my heart, appear in front of me and a panel on which I serve as an oral advocate. I thought all of you were fantastic. To a person, it was a very difficult decision. I said to our group of judges that I would much rather decide the legal issues than who was the better set of oralists here. And I mean that sincerely. I thought each of you had great skills. I think you will do wonderful things. I hope you will have an opportunity to be in jobs where you do get to advocate on behalf of a client in front of a court, both at the motions practice, which will be very similar to what you did, and before courts of appeals. And I hope that you will have the opportunity to put in the time and effort and demonstrate the skills in your future life that are just starting to germinate here, because you guys will be great, and I think the legal profession, you all being representatives of the up-and-comers, is in great shape. So thank you.
Let me echo that. I thought all of you were truly outstanding. The day that you graduate and join the profession, you will be already at the tippity top of the field of oral advocates, and that's telling, and that's something that reflects incredibly well on all four of you. I thought that you, to a person, dealt in an exemplary way with a very hot bench, and were able to navigate through the thicket of questions, particularly Ms. Bernard and Mr. McClure. You both did the same. Both were able to navigate it in that way and very, very intelligently and answer the questions. Same thing with you, Mr. Hilton. I thought you had a hard time, had a hard argument to make, and you were trying to dig yourself out. And I thought that was admirable and very well done. Now, Mr. Alisi, you didn't have as many questions, ironically. But obviously, we all thought that you did a great job. And just to echo what Judge Hall said, I would be honored to have you appear and argue in the way that you did today before the Second Circuit.
Well, I'll echo all the things that have been said so far. I, too, have had a lifetime career in labor management relations. Started my career as an appellate advocate, and have actually had a chance to sit on an appellate tribunal, not as esteemed perhaps as the Second Circuit, but certainly one that has important national jurisdiction. And I will tell you, I think that appellate advocacy is some of the toughest advocacy you can do. First, you're not making the record you want. You have the record that you got. Secondly, you are dealing many times with a hot bench, having to deal with lots of different questions coming from different directions and think on your feet, why am I being asked this question and what trap I might be getting into, and depending on how I answered it. And it's a lot like riding a horse. You know, your horse wants to nibble off in this direction, to nibble off in that direction. If you're on a trail, you've got to constantly pull that horse back on the trail. And all of you did a very good job of letting the horse nibble a little bit, which you have to do, and you got it back on the trail, back to your points. And I think all of you did an excellent job doing that. And I agree with all my fellow judges here that I think you all have great careers in the law ahead of you, and congratulations.
I just want to add my comments to my colleagues. I agree with everything they've said. And I sort of want to pause for 1 second and ask a little question, a kind of a thought exercise. It's about 65 degrees. The sun is out. It's a gorgeous day in New York City. And I look around this room, and there are 100-plus people who have given up that Sunday to be here. And so the question is, why? You know, what's driving people to be in this room today? And I'm struck, as I am on these occasions often, with the commitment to professional development that the students in this room have, and that the coaches have, and that the parents have, who are here to watch their children make their arguments. And I'm struck by the idea that the profession is in good hands when people show that level of commitment to anything. And so your preparation for the argument, the sense of real deep investment of time and energy that all of you have put in are really exemplary. And, you know, just to toot our horn here at the law school a little bit, there are really a whole bunch of people who didn't have to be here who are here. Students, your fellow students, faculty members at the law school who have come, and they don't have a dog in this fight, as we like to say. But they're all here today because they support the concept of education. They support the concept that what we do in these exercises are about training the next generation of lawyers. And it makes me incredibly proud that we can see that level of commitment coming from lots of different places, 50 different schools, you know, lots of different people from different parts of the world who have made this their commitment into the future. So I just want to commend all of you for demonstrating that whatever people want to say about our profession, they get it wrong. So on behalf of all my colleagues at New York Law School, once again, I want to thank all of you for your commitment, and to Susan Abraham, our moot court advisor, Arthur Leonard, Peggy Leibowitz, the faculty members who worked on the problem. A special thanks to you for guiding our students so well. And to the members of this moot court team who put together the problem, I want to thank you, and I'm sure that your colleagues and friends from these two schools are delighted that you put together a good problem, one that allowed them to shine and to show to the world their excellence. So thanks all of you for being here.
I'd just like to thank New York Law School and the moot court competition on behalf of my colleagues for choosing all of us to participate in this. It was a privilege for us. I want to thank my colleagues for their excellent questions. It made me think. And thank you all for participating in this afternoon event. It's terrific.
Thank you, Chief.
So I think that there's actually a fun part that happens now, which is the actual hardware gets distributed.
About to carry back.
You want to see this
Oh,
picture?
sure. This is where we...
This is the part where the parents actually do get to have some pride because the picture gets to go home with them.
Oh, we're going over there? That work good?
And just because people don't know the question, the answer to this question, which schools are these two schools? Northern Kentucky. So Northern Kentucky was respondent and
Mississippi College.
Mississippi College.
See, now, don't you guys love our fat guys so much?